I quite like the way that the French DPA started. They went, you mentioned Victory, they went after few non-compliant companies. They showed them what was wrong. They gave them 6 months to comply. If they complied, they said it's okay. And if they were not, they gave a fine. I think this is what I would hope every DPA would have done.
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs, and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. We have Tara Taubman here today. She's a French lawyer specialized in privacy, internet law, and intellectual property. She's a published author for many years raising awareness of privacy, data protection, and cybersecurity issues. Tara has also launched Fly a Kite, which is an initiative to raise cybersecurity awareness, especially to keep kids safe online. And she's also a fellow Queen Mary University LLM alumni, which is a great place for IT, IP, and internet law that I hold very dear. And in any case, we're going to talk about the Instagram fine, the 405 million euros that the Irish DPC is asking Meta to pay. And of course, the one-stop shop, which is the hot debate around that topic. And then we'll take it into TikTok terrain and well beyond. Let's start. Tara, thanks for joining me.
My pleasure. Thanks for inviting me to be here.
Look, just to warm up, we have this thing going on with Instagram. There's been much back and forth with other DPAs, and finally Ireland's agency, the DPC, has fined Meta 405 million euros. And the fine, unlike other things we had seen in the past, which concerned dealing with children's data, or in the case of, for example, TikTok, allowing them to sign up without parental consent and so on. Here, what's peculiar is that Instagram was showing their contact details publicly. What do you think about this case? What would you say about it, or is it a good start?
There are a few interesting points in this case. One is we are actually witnessing European DPA openly criticizing the Irish DPA, not only for the decision, not only for the amount of the fine, but for the way that she had actually done her investigation. So it's quite a direct confrontation. GDPR is a regulation, which is a very ambitious piece of law. It took years for Reading to come to an agreement between all the different countries coming from different legal backgrounds. The regulation mainly applies directly into national legislation, and there is a principle of consistency mechanism, which means the hope is at the top there is some regulation, every 28 or 9 countries would apply them exactly in the same way. 2 years later, we've seen already a publication of a document by European Data Protection Board on the disparity and discrepancy on the amount of fine. As everyone knows, the Spanish DPA is distributing many smaller fines. Italians and the French are active. And the Irish DPA has been dormant. It has caused issues. Ireland is a smaller country, but has the biggest US corporations and social media companies based in Ireland. So they are the ones who are escaping. And we've seen when other DPAs, like the CNIL, when they try to fine, they keep saying, oh, you're not the competent one. We are under the protection of the Irish DPA. Leave us alone. And it's been clarified. It is now stated that in many cases, the CNIL or other DPA have rights to fine a company that is based in Ireland. We're not going to enter into the detail of what the criteria are, but they've been able to do it. Now with the Meta case, it's been going on for years. It started 2020. We are now 2022. And finally, Irish DPA fined Meta. They find the reducing the amount of the fine. I personally, I'm not that focused on the amount of fine. They're all just tickles for these big companies. There's 1 or 2 days of revenues, so it doesn't change that much. Going to chase the big corporations means risk of appeal and appeal costs. So the Irish DPA has been saying we are lacking resources. They've now got more resources. A delegation of European board have visited the Irish DPA and have said something has to be done. So this is where we are, and this is the context of this decision. What's been criticized didn't need any resource. It's more the way that the Irish DPA actually analyzed the fact that's been criticized. And the group of DPA who contested that were approved by the European Data Protection Board. So what was behind that was the fact that Instagram had set up a new business account. Underage children could have business accounts. How they check actually the age of anyone, for me, is a mystery. I personally do not believe on any age verification tool online. Anyone can pretend to be anything. The only way it could work if we had a digital ID, which no way I would want Instagram or Facebook or even LinkedIn to access to it.
That's the thing.
We are in a situation where they are admitting that they are underage kids opening business account. While they opened the business account, without sufficient transparency, their data, which is basically their name, address, phone number, email, was publicly published. What's contested by this group of DPA that the Irish did not take the sufficient conclusion about it is that this information were publicly published without clear transparency and without being necessary. So there's been a debate in front of the European Data Protection Board on checking were these information public, were necessary or not. Instagram used 2 lawful bases to collect and publish this data. One is execution of a contract, and the other one is a legitimate interest. What's different between two, why they decided one better than the other, is because in some countries, underage children cannot by law consent to a contract. So there is countries, although GDPR is common to everyone, in some countries, national regulation protect further the underage children by saying you cannot sign a contract because you're underage and you need your parents' consent for that. So Instagram were bypassing this obligation by saying we have a legitimate interest to do that. You have a business account, so let us publish everything online.
So then there's 2 separate problems, right? One of them is that children or underage are opening up accounts. That's one problem. And that's common to other platforms, right? And another one is that now once you're on the platform, even if you are over 13 and your jurisdiction already allows you to do things, because some jurisdictions, as we know in Europe, across Europe, children is a different concept in every country, like Netherlands 15 years, Germany 16, the UK was 13. So even if you still have the age, then as you use the platform, and it happens in many of these platforms, if you sign up for the business account, you get to say these engagement metrics that are so juicy and so useful to influencers or influencers to be, where if you want to see who's accessing your posts, you want to have a business account, and you're sort of pushed into that because then you see more. But the minute you sign into that, as you're saying, you may not be a child as per children data, but you're still not allowed to enter into a contract because in your jurisdiction you need to be 18. And that's what you're saying. And in some jurisdictions, then the legal basis that applies is contractual, because, for example, in Scotland, I believe it's in Scotland, you can enter into a contract being 16, for example, but it wouldn't be the case in other jurisdictions. So then for those, they're applying legitimate interest.
Yeah, exactly.
Yeah.
In both case of contract or legitimate interest, the processing of the data has to be necessary. You can have a contract, but do we need to process that? Yes or no depends on, is it necessary or not? Was it necessary to publicly publish these kids' information? Well, they are claiming that it wasn't, because once Instagram changed their way of doing it, they were not publishing it and it was still working. So that's what these DPAs are using to say, well, we have a proof that it wasn't necessary, so it should have never been published.
And do you think that maybe, I haven't had access to the reasoning, but since an Instagram business account, like a WhatsApp business account, I see that in WhatsApp. It's like in WhatsApp, it's also so easy to see how it pushes people into opening a WhatsApp business account, because you can have like auto reply and certain features that are not available to a non-business account. But the minute you've got a business account, it does the same thing. It's publishing certain data out there, and it's sort of pushing you to share more. And I'm thinking perhaps this has something to do with the original e-commerce directive as it was implemented, where we are all required to publish contact information when we set up a business website. And do you think they have, or perhaps I'm assuming too much of good faith on the part of Meta, that since you're now a business, even though you're 16, let's assume that you are a business, therefore now you are obliged to share your contact details as per e-commerce directive in your country.
You are mentioning a very interesting point. Yes, indeed, e-commerce directive asks every website to have a information published and a mean of contact, and even you are expected to respond within the 48 hours or 48 hours any requests. I have actually looked at that. Not many websites are actually conform to this. And I've had my Twitter account that was blocked some years ago. And there was no mean of contact of Twitter. My account was blocked. It was deblocked. Some people launched a free Clarinet, and I never knew why I was blocked, and I never knew how I was deblocked.
And there was even a campaign to defend you.
Yeah. I had my league of defense. So yes, it should be published. But then what we can say is, in these countries where underage children cannot sign a contract, they cannot have a business, so they shouldn't be in a business account situation. This is why these national jurisdictions have tried to protect the children. And what Instagram is doing is bypassing these rules.
Yeah. Okay, so then to summarize, we've got, let's say that, assuming that they did a good job, which I agree with you, I find it very hard, verifying that they are over 13 at least, that they may be over 13, therefore they're not in a TikTok scenario as per recent cases, but they're under 18, so they're not allowed to enter into a contract. And then we're assuming legitimate interest, but something like an e-commerce directive wouldn't apply anyway, because if they cannot enter into a contract, they cannot run a business. So why legitimate interest? And then So the next question for you would be, so then now this data is shared publicly, and as you said, there's this contact information. So it's not like, sensitive data and so on, but then there's the question, what is more important or what is more of a threat? Your email address and phone number, in the case of someone that is like 16 or 15 years old, or being profiled and, potentially being targeted according to something that is Article 9 related. So do you think this is really more of a challenge for their future or a privacy violation than other privacy violations associated to profiling? The fact that your data is not confidential anymore. In other words, it's a confidentiality issue. And is it tied to a greater privacy challenge? Or how do you see that?
What the DPA contesting the Irish ones have put in front is it's a compliance issue. They should have done the necessity test. There should be a balancing test. There should be transparency. So they looked mostly at it from a compliancy perspective. What some said, like a French clean has said, what are the risk of not complying are potential stalking or going after some of the children who are publishing the data. And Meta has been contesting that, but saying there is no risk, actually. We didn't comply with there is no risk by publishing it. And we could argue that a lot of these young people are anyway publishing all this information everywhere on Facebook and everything. But the compliance says the test should be done and there should be transparency. And then there should be a lawful basis on processing, and the children should take a decision knowing exactly what they're doing. This is why transparency is important. Would they necessarily expect that their data would be openly published? Maybe not. Actually, some of these kids would publish, they say, everything on their Facebook page, but not to their parent. So once Instagram publish it to everyone, parents can see what they don't want people to see.
I saw another possibility that is an even bigger threat. These days, the exchanges of first-party data is all the rage these days, and first-party data is what is allowing people to build profiles across the board, where we used to have third-party cookies, and now everyone is migrating very fast to first-party data. But in a way, it becomes third-party, because there's all sorts of solutions out there to deduplicate first-party data, meaning to match people across different profiles on the basis of their email address and sometimes phone number. So I see there's an opening here to a much bigger challenge. Not just the fact that people could be contacting your kids, but the fact that now there is a primary key, there is a hook, there is a connection between whichever profile Facebook may have of them, which goes very deep, as we know, and their online activity across the web, because now there's that bridge and they can be deduplicated. So in theory, they could be targeted more efficiently if you build a pool of these email addresses. And again, it wouldn't be about the human challenge of the one-to-one call or stalking, but instead the danger of automation around the first-party data. And I hadn't thought of that.
This is very true. That it's that's something that for non-techie or people who have not been thinking into that area don't always get. Is you go to the doctor and the doctor used to call you in a surgery by your full name. It was okay because it was within that room, within that village, within that location. Today you go to the doctor, if they call you from your full name, anyone in the room would Google and know exactly who you are.
How terrible is that? I'm always thinking in these waiting rooms, hospitals.
And I'm going to a clinic for abortion or a clinic for adoption or a clinic for whatever. I don't want people to know that. And people go there and they publish it. I wrote an article about why privacy matters. And I'm referring two of my mentors in that field. The big one is Daniel Solow. He's an American scholar. And he tells the story of a lady who threw a cat in a bin. And someone actually record that and it goes viral online. This poor woman lost her life because forever she is the cat killer. And once you've got this label, it's very difficult to get rid of it. And for young children, when they start their life, being labeled with something follows them. So there are all kinds of businesses, some kind of businesses that child might not want to be associated with all his life. And they are too young. Kids by definition are impulsive. They don't realize exactly where it goes, how long it stayed there, and how it's going to follow them all their life. They don't know which kind of job they want to do later on. So in some professions, it's more important to have done this or that. It was a picture of a young lady drinking beer in a not very traditional conform situation, but she didn't care. She was a young girl, but then she became a teacher. As a teacher, it matters. Parents went and see this. So yeah, this ability of the internet to curate and do further processing of a first party data is why national legislation have been trying to more protect underage children.
Very good point. And so, do you think that there is a solution with regards to now the area? So, I understand this is a bit of a political drama here involved, because American companies, well, now TikTok as well, if I understand it well, they're also in Ireland. So it's like the easy jurisdictions. If there's a one-stop shop and you want to be an attractive jurisdiction, not just for tax purposes, but also, and of course, jobs, the language, so English-speaking country, but also the fact that it's friendly in terms of, process your data from here, because we're more, we're more pro-business. I guess that is a bit of a political challenge because it's coupled with tax advantages that in a way hurt other jurisdictions. Do you see a lot of friction there? Is there a way to solve it? Do you think there'll be political measures perhaps replacing the DPC, the head of the DPC in Ireland? Is there anything happening in that regard?
Well, it is a fact that Ireland has been trying to attract these big companies, and they are big employers in Ireland. So finding them is not very politically correct. It's not, and yeah, to be honest, the Irish DPC is not in a comfortable situation. She is tiered. There are a lot of lobbying going on within Ireland, within the European institution. These big companies got big money and they've got big influence. We saw the Uber files coming out. The lobbying done by Uber within the European academic expert and politics certainly happened in different US corporations. And where unfortunately EU is waking up a little bit late because we've lost our digital sovereignty. We are totally dependent on US corporation.
That's such a good point. I mean, I was thinking I wouldn't want to be in her shoes, as head of a DPC, because you're right. There's so much pressure, and the lobbying. You're right. In the US, there's a tradition of lobbying in DC, and now I know for the past 2 years by reading Politico and other places, there's been sort of an invasion in Brussels, and there's so much money that it starts permeating, and not just, of course, direct lobbying as we've seen it in the hallways of the parliament and to just push a question and so on, but also, and I've seen that, but also now we start seeing it permeating through the thought leadership system. So yeah, scholars, whoever writes, a very subtle approach to influencing, because that's their job. So it's really hard to deal with that.
There are big money, they make huge profit. So would they take their hands off kids' data, which is a big business? We don't know what the influencers do, what YouTube is doing. They continuously push young people to reveal data. And we know now that lots of these quizzes that are done in Facebook, they're not just a game. I wonder how many young kids have not realized that, but they are still extremely popular. And where it's important is not only the quiz and all this information that is published online. relate to the person who is publishing them only, but they also reveal a lot about other people. The same way as I often criticize people who do DNA tests. They not only publish their DNA, but the DNA of the family. I would say what I wish the GDPR had better dealt with is actually the data brokerage industry. GDPR is asking a lot of common sense from every companies, which is good. It's actually great for raising security. Data minimization is just common sense. Limitation of access is very healthy. All is good. But that doesn't fight against the data brokerage industry that is actually doing all this further and processing of the data. And it's a huge industry, it's big money.
Well, and one last question then, Tara, about that, because I agree. Data brokerage is about an open market where data is flowing, and in a way, it has taken shape because that open market didn't have the muscle that some walled gardens like Facebook or Google had. They have so much muscle within their walls that they could already do their own, again, very advanced data processing, algorithms, profiling. But now, because other smaller players and of course media as a whole, publishers want to compete with them, data brokerage is a big industry because you need to share profiles across the board, and this applies to smaller players. And I think what I've seen is the biggest violations are happening with players that are in that game. And I question, or it's a question for you, do you think we're strong enough in Europe that we have the will to enforce with the same strength, enforce GDPR against European companies, knowing that very often it's European players who can be the worst, even with children data? I'm thinking there's a company that is, well, I won't mention it now, but it leads every ranking in terms of apps for children or games that children tend to install. There's no age verification. It collects, every single one of these games, they top the charts. They collect massive amounts of data. For every audit that we've been doing with apps, these collect everything out of every phone. Kids agree to all of these terms, so they give consent because they're not really, knowing what they're doing. And then they keep using the apps, there's ads, there's trackers, and they are passing this data over to a crazy, huge chain of custody. But they are EU-based. I believe there's been one fine tied to this in France. It was the Vectauri fine about the way they collected consent back in the day. But the app developer itself was never touched that I know, and it's based in Europe. Do you think, and Americans keep accusing, or American companies and scholars, or some people, at least those that I follow on Twitter, they keep accusing the European institutions of marginalizing US companies. Do you think there is such thing? Do you think we're biased in Brussels in terms of legislation and enforcement, or do you think that we have the willpower to also go against European companies that perhaps sometimes are even worse when it comes to data brokerage?
I don't believe the EU institutions have been biased against the US corporation. One good thing is that GDPR doesn't take account of the nationality of the data subject, is whoever is based within the EU or European Economic Area. While what the Americans are doing is giving less right to US citizens against the American citizens. So I would see more bias on the other side. Since 2018, although the GDPR wasn't a revolution, it was a follow-up from the directive. Hope was big after GDPR because big fines make the big headlines, and not everybody knows about data protection. What we were hoping that Data Protection Authority would do, they didn't actually did what was in the hope. There was 2 years of COVID that surely slowed down the activities. I quite like the way that the French DPA started. They went, you mentioned Victory, they went after few non-compliant companies. They showed them what was wrong. They gave them 6 months to comply. If they complied, they said it's okay. And if they were not, they gave a fine. I think this is what I would hope every DPA would have done. Why they went through more bigger US company? Well, part of it is because we have a big human rights defense association like None of Your Business, or the French like Quoi du Net, or Privacy International in UK, who actually put a complaint against these big ones. So DPA had to go and look what the big ones are doing. I am not convinced if that's the best way to go. As I've mentioned, big ones got big money and big appeal, so it costs a lot of money and resource. So going and checking what the everyday business in Europe do could be a better option. That's my personal.
Well, thank you, and I would question that, but that's for another day, because of course I look at the Spanish DPA and all of these €1,600,000 fines to tiny little companies.
Well, I'm against fine. I wrote an article about that people can read. I don't think fining is necessarily the best thing.
Good. Well, okay, I'll be interested to read that, and we'll add a link to that. Tara, thanks a lot. Thanks for joining us.
My pleasure. Thanks for having me.
Okay, that's all for today, and you will find some episode notes and links to our social channels on mastersofprivacy.com. Thank you for listening.